Good afternoon and welcome to The Appeal Live, a co-production of Now This and The Appeal. I'm Emily Galvan-Almanza, and today we're going to be talking about something that's this little known aspect of criminal procedure that many people might not be aware of. When we think about jury trials, lots of you are probably familiar with the idea of the unanimous jury verdict. So for a jury to find someone guilty or not guilty, all the jurors have to agree on a conviction or an acquittal. Split verdicts lead to what's known as a hung jury or a deadlocked jury, which triggers a mistrial. Now, I managed to get all the way through law school thinking that that was just a given, this was gospel, but it turns out I was wrong, and you might be too. So unanimous jury verdicts have long been the standard. Those of us who are wrong are not to be blamed for our wrongness. They're the standard pretty much everywhere in the US, but they're not universal. So until pretty recently, Louisiana and Oregon both still allowed non-unanimous jury verdicts. Now what that means is people could get convicted on most charges and go to prison on a best of 12 standard where 10 out of 12 jurors agreed on guilt. Two people could think that person was innocent and that person would still go to prison in Louisiana or Oregon. But in 2018, Louisiana voters approved a constitutional amendment doing away with split jury verdicts. Then last April, the Supreme Court ruled that non-unanimous convictions were unconstitutional, forcing Oregon to get in line with the rest of us and join the rest of the nation in using unanimous jury verdicts. So in this ruling, the Supreme Court found that non-unanimous juries stemmed from Jim Crow era racist attitudes designed to silence the voices of Black jurors. So already Jim Crow set up a million hurdles designed to keep Black people from serving on juries. Many of these hurdles still come into play today when Black people and other marginalized people have a much harder time getting onto juries to serve and have their voices heard as members of the community in this manner. Now, non-unanimous juries, with that in place, even if a few Black jurors did manage to make it onto a trial, a large majority of white jurors could simply overrule them. So in Louisiana, the racist roots of non-unanimous convictions were open and explicit and stemmed from an 1898 state constitutional convention that was designed to, and I'm going to quote here, the quote is, it was designed to establish the supremacy of the white race. Now, despite this clear racism behind the concept of the non-unanimous convictions, the recent actions doing away with them were not made retroactive. What do I mean by that? I mean that for people who were already convicted on this best of 12 standard, the law does not automatically allow them to be released and get a new trial. In Louisiana, for example, 1,600 people are still incarcerated on convictions by non-unanimous juries. Convictions where at least one juror thought this person was not guilty. Now, some of these convictions led to people being sentenced to life without the possibility of parole. These are very, very serious sentences. We're not talking about minor jail time. Now, all of this brings us to New Orleans, where newly elected Orleans Parish DA Jason Williams has launched the Jim Crow Jury Project to review non-unanimous convictions in light of the voters' decision to prohibit them going forward. Now, as part of that effort, Williams has vowed to review more than 300 of these convictions that took place in Orleans Parish between 1974 and 2014. Last month, his office announced it had vacated convictions for 22 people who were convicted by split juries. Now, to talk more on this effort and the issue of non-unanimous juries, I am very happy to be joined by Orleans Parish DA Jason Williams. District Attorney, thank you so much for being here with us today to talk about this.
It's good to be with you, Emily.
So let's dive right in. What is the Jim Crow Jury Project? Why is it called that? And what are you doing?
So the Jim Crow Jury Project is our initiative to undo decades of a racist plan to marginalize Black voices. And what we're endeavoring to do with this project and with this initiative is to send a very clear message that this is no longer a Jim Crow office. New Orleans has been ground zero for unfairness in the criminal legal system for Black and brown folks for a number of years. This non-unanimous jury piece has been a major component of that. And in order to deliver on this for the people of New Orleans, we have hit the ground running. And one of our top priorities was focusing on correcting the sins of the past so that we can begin to rebuild trust in community. And recognizing that previous DAs, previous administrations have caused real hurt and real harm to the city. And while this administration wasn't responsible for the damage that it was done, it is certainly our job to address that harm. The fact that a conservative Supreme Court found it absolutely clear that the goal of this law in the 1800s was to enforce racial segregation. Chief Justice Kavanaugh made it clear, and he's very, very conservative, what this was rooted in. So the idea that this was sort of negligent or an accident, that was made abundantly clear, but it wasn't made retroactive. And if something is going to be declared racist, then it's not racist going forward. We've got to address all of the seeds and fruits of that racism.
I'm so glad you mentioned that, because I agree that I don't usually think of Justice Kavanaugh as like a Black Lives Matter activist on the bench. So for Justice Kavanaugh to be clearly calling this practice out as racist is notable. I'm wondering if you could dig into, you mentioned this is no longer a Jim Crow office. And I know it can be really challenging for especially prosecutorial offices to undergo great change, especially great change that may have ripple effects through past practices, may need to be implemented across all levels of the office. And I'm wondering if you could talk with us for just a second about what it's been like implementing these changes in an office with such an outlier legacy.
Yeah, so just launching into the Herculean effort of changing culture, changing attitudes, changing mindsets. For a very long time, we have been the incarceration capital of the country, which means we're the incarceration capital of the world, right? So prosecutors have deemed success as being as in accepting as many cases as we can, and then prosecuting as many cases as we can, and in giving more time than any other jurisdiction. So the idea of undoing those convictions has not been easy. It is not, it has not been easy within the halls of this office, or within the walls of this office, or outside. But I think that when you look at the fact that we had in 2018 an incredible campaign led by the Yes on 2 coalition to educate voters in the state. And once they were educated, they voted and spoke with a resounding voice saying, we don't want to be a Jim Crow state. And so we're riding that wave of progress and reform and equity to do what voters have asked us to do. And so couching our efforts in that and having quotes from Kavanaugh that make it really clear, regardless of party affiliation, regardless of race, of socioeconomic status, this was a plan put in place by racists at the same time that there were attacks on an integrated police force, at the same time that monuments of white supremacy were being put in place, at the peak of lynchings. This was a component of that entire plan. And so being very honest about that during that Yes on 2 campaign allows us to be just as honest about our endeavor to undo these Jim Crow prosecutions.
So I want to talk about exactly how you're doing. I want to get into the nitty-gritty of the mechanism. How is the Jim Crow Jury Project going so far? How does the review process work? And what can you tell us about the 22 convictions that have already been vacated?
It's going very, very well so far. One of the first hires I made in my office was a chief of our Civil Rights Division. The Civil Rights Division is looking at excessive sentences. It is looking at these RAMOs, or non-unanimous jury convictions, and it's also looking at wrongful convictions, right? So building out that office, properly staffing that office with real resources has allowed us to do this work with some degree of integrity, as well as efficiency. We hired Emily Ma to lead that work. She's a former director of the Innocence Project New Orleans. So she's not new to this work. She is a direct report to me. There are a lot of other offices where the Civil Rights Division or the Wrongful Conviction Unit falls under the appellate union, which sometimes creates a bit of conflict between lawyers that are trying to maintain convictions versus lawyers that are reviewing convictions, right? So that direct reporting element is working out really well so far. Last month, we began by vacating 22 convictions in Section G. Section G of Criminal District Court had the most of these non-unanimous juries. There was a time period when the judge there was having as many as 5 or 6 trials in a day, right? Some of them very, very serious murder cases lasting as short as 2 or 3 hours, right? So there were a lot of atrocities that were part of this mass producing of convictions. So that's why we started in that section of court. I'm looking at your face and you can see just how absurd the suggestion is that you could get a fair trial in a murder case in 2 days, and that includes jury selection. So we're beginning with a very methodical process of going section by section of the 12 sections of court, starting with the most populated section of these cases. And that allows us to do victim outreach, right? Because it's still really important that we reach out to the victims and survivors of these cases to make sure they understood, one, what the Supreme Court decided, two, what voters decided, and the fact that those decisions have had an impact on their cases, and that we are proactively dealing with this 365 some odd cases so they don't just fall out of the sky, basically coming from Fourth Circuit and Supreme Court rulings at a time when we cannot control when they will hit court dockets. This allows us to review them systemically and have a certain amount of order with regards to victim outreach.
So speaking of victim outreach, I do want to mention for our viewers, yes, I gasped, by the way. My face was, I was looking appalled because 2 hours for a murder trial or even 2 days for murder, like I think of murder trials as a thing that takes like months. So that's like someone saying, I don't know, I delivered a baby in 10 minutes. Like that's not how long this process takes. This process is painful and long. Yeah. But going back for a second to Frederick Edwards v. Louisiana, that's currently pending right now, just so our viewers have some context. There's a case pending in front of the Supreme Court that asks the court to decide whether that 2020 ruling barring non-unanimous jury verdicts should apply to past convictions. And as I understand it, the Orleans Parish DA, as we just heard, is looking back at those retroactive cases anyway. DA Williams has staffed up this unit. But I want to dig in because you've mentioned about 300 people who came out of your parish. Seems like a lot of them out of Section G. But there are 1,600 people statewide. And I'm wondering if you could talk about, if the court does not apply this prohibition retroactively, what can you still do to push for relief for those people outside of your parish?
So we're moving forward section by section. We are compiling all of our data to share with the Louisiana District Attorneys Association so they can understand what this process looks like for the busiest court in the state, right? And so they can understand that it is not 22 people being released the day that you begin to deal with these cases. 16 out of 22 folks have agreed to plead guilty within very short order of this case. Now, some of them might have been facing 76 years in jail, and their sentences have been reduced to pleas that are closer to 40, 50 years in jail. And some of them have already served that time. They're coming out at age in their 60s and in their 70s, right? So this is not some wholesale release from jail. But what it is doing, it is properly addressing harms that occurred. If the decision was made by the Supreme Court that it was racist, then we cannot. There is no end around or redress to that without actually dealing with these cases. So we're sharing our data with all the other DAs from around the state so they can understand what our process was, what our victim outreach was. So there's at least a blueprint for folks who want to address these cases and not just wait to see what happens.
On that victim outreach, I mean, I imagine that survivors of crime probably want the right person to be behind bars, not just like any person who was available and harmed by a racist system. Does that reflect your experience? What do survivors want?
It does. Survivors, number one, just want good, clear communication. And that has not been happening in our office. We started off with we found about 6 victim outreach persons in this office for 12 sections of court. Clearly, that's not enough. So we've been able to identify that as a deficit in the office. But I've met with a lot of victims and survivors and families of victims in the 60 some odd days that I've been here, and they just want to know what's going on. Many of them, surprisingly, I hadn't even thought about it, actually voted for this change, were a part of this change. Many of them voted for me. Many of them are supportive of criminal justice reform, and they just didn't even realize that this would be affecting a case that they played a part in many years ago. So really, what I'm finding for victims and survivors and families is they just want clear communication. And you're right, Emily, they want to make sure that the right person was in jail, and that person, if it was the right person, had a fair trial, right? And some of the cases require us to look at Brady evidence that maybe wasn't disclosed, other unconstitutional or racial profiling that might have occurred by improper police work. Those cases are in the minority, but we're absolutely taking that opportunity to look into that as well to make sure that the right person is serving time.
It sounds like you're uncovering a lot of stuff beyond the jury problem, a lot of other gross stuff in these cases. And I'm wondering, as you think about this as a slightly more expansive vision, a vision of a unit that tries to get it right, whether that's about non-unanimous jury verdicts or wrongful conviction of other kinds, with the support of survivors in the community who have voted for these initiatives, it seems like you're talking about more of a movement than a local DA's office initiative. And I'm wondering, as we think of this as a movement, what can Governor John Bel Edwards do on his end? Is there more the governor could be doing to right these wrongs?
The governor was really amazing, and he's a good friend. He happens to be a Democrat. It's a Republican state, but he has been really strong on criminal justice reform more broadly. He's been really strong on reducing excessive sentences from a statewide level, which has created a certain degree of uniformity and just it's a symbiotic relationship between the reform efforts that we're endeavoring into here. So I don't feel as much like an outlier as I might have had we had a more conservative governor who was pushing the other direction. The important part is really education here and making people understand not just the what, but the how and the why, right? And when people get the why, regardless of party affiliation, there seems to be overwhelming support of this, because people understand that if the wrong person is in jail, if an innocent person is in jail in these situations, it means the real offender was left out on the street to reoffend, right? And so that is really important to the victims I've talked to, and the governor's been really helpful in getting that word out and getting that message out. And it's important, although I'm just in New Orleans, it's important for folks from around the state to really understand what the city that was the largest driver to incarceration is doing to end mass incarceration.
So you mentioned that this is right now we're talking parish local, and we're blowing it out to talk about the state of Louisiana, but Oregon, a state that has very little else in common with Louisiana, is traveling the same path. And I'm wondering if you would be willing to share anything that you've learned in this process that you can pass on to Oregon Attorney General Ellen Rosenblum in navigating this.
Yeah, so a good friend of mine, a former board member of mine from the Innocence Project, Calvin Duncan, who was exonerated, he's out in law school there, right? So I've been able to follow Oregon's pathway. And I think what's really important is that there are moments where states can lead and cities can lead. And we should, because we are more nimble. And when a state or like Louisiana and a city or parish my size can come up with a system and be nimble and lead in doing this work, I think it lays out a blueprint that can serve to be a major paradigm shift, because the sky did not fall the Friday that we reversed those 22 convictions. In fact, it brought a lot of trust back into a system that had been breaching the trust with the public for a very, very long time. So it also, and I would say to my colleagues in Oregon, it's an excellent way to address a very tough summer that the criminal legal system has gone through in terms of not being accountable to all neighborhoods and not addressing police and prosecutorial harms in all neighborhoods. This is a way to begin to show every single neighborhood, especially black ones, especially brown and beige ones, that all voices matter, all voices count. And by the prosecutor being proactive in this regard, I think it opens up a door to people to believe that the prosecutor actually works for them as well.
So there's a question that's been on my mind as we've been talking about this stuff, which is that we have a situation here, lawyer to lawyer. The Supreme Court said this is really racist and is something that arose from a past where the law was being deliberately designed to harm Black Americans. And when I think of American law, off the top of my head, I can come up with a lot of other stuff that falls into that category. Felony disenfranchisement and black codes and so much of the way policing works and has evolved from slave patrols. And I have to ask you this broader question, which is, if the Supreme Court says a thing that was built out of racism cannot be sustained and supported today, we have to change it. Are there other areas of the law, of the criminal legal system, of your work that you see that principle applying to? Is there
absolutely. I mean, Cornell wrote a book a very, very long time ago, Race Matters, right? We cannot pretend that we got where we are in the criminal legal system by happenstance. And if we look at our gun laws, right, and we look at how they're being applied, that's a really good analogy or a good example of what you just described. You look at the number of individuals that are stopped daily because there's a tip that says a person was seen with a firearm, right? When it's a black male in a poor neighborhood, there's a thinking that is probable cause for an arrest, regardless of the fact that there's a right to bear arms that applies to all American citizens. And you very rarely hear the NRA or conservative members of Congress come to defend that young black male who was stopped because of the presence of a firearm, although those are the same folks who you hear push the stand your ground law or pop up every time there's a school shooting, or the fact that you very frequently see someone charged with being a felon in possession of a firearm because they had a simple possession of cocaine case 8 years ago, right? Well, that is really designed. Those laws are being applied that way to keep guns out of the hands of certain people, but not necessarily to keep guns off of our streets, right? So there are a number of applications, or should I say misapplications of laws that are rooted in white supremacy or a fear or belief that blackness equals criminality. If you look at the misuse or overuse of the habitual offender laws in urban settings, right? We have the habitual offender law here in the state, but it is misapplied or disproportionately applied was before I got elected, was disproportionately applied in this city where it is predominantly black. But you look at predominantly white parishes, and the habitual offender law was not used at the same rate. So there's a number of places in which you could see the exact example that you just described. And I think we are now in 2021 beginning to have very real conversations about these things, and we simply have ignored them for many years.
Well, that is a perfect place for us to close this show. D.A. Williams, thank you so much for joining us, for digging into this stuff, for reviewing these cases. I wish you the best of luck in getting people out.
Thank you, Emily.
Take care. So there you have it, non-unanimous jury convictions, a clearly racist relic of the Jim Crow past that are finally being cast into the dustbin of history. But will they be cast out, or will they, like many of the racist relics that still prove pervasive in our criminal legal system, will they persevere and die a slow and drawn-out death? We just heard from Orleans Parish DA Jason Williams, who is working to speed this process along in New Orleans, is not waiting for the Supreme Court to tell him he has to review these cases retroactively, but has rather established a unit, hired staff from the Innocence Project, and tasked this unit with reviewing both non-unanimous jury conviction cases and other forms of wrongful convictions to try and, with survivor support, bring people home who should not have been sent away to begin with. He mentioned the really deeply problematic legacy of his jurisdiction, and he's got a lot to unpack. It's interesting to me the way he talked about survivor voices and the way he thinks of his community. You know, prosecutors stand up and they say they represent the people. They say so-and-so for the people. We've all heard it on television or in person. But when they say the people, I think they often don't really mean all the people. When D.A. Williams talked about survivors who voted for reform that would end non-unanimous jury convictions, when we talk about people who have been harmed by crime, but who also want to see criminal legal reform, and they want to begin to dismantle a system that is structurally racist and oppressive, it's interesting to me how often those people are forgotten when DAs stand up and say for the people. Sometimes I think DAs stand up and say for the people, and what they mean is I want to increase my conviction rate, and for the people means for my office. But in fact, it seems like DA Williams here is really incorporating all the people. I'm impressed by the note on which we ended, which is this question, right? If the Supreme Court, if Justice Kavanaugh will say that non-unanimous jury convictions are born of our Jim Crow past, are a racist relic, and therefore cannot be supported or sustained, what does that mean for the other things in our system that have the same racist legacy? D.A. Williams talked about the way gun laws are enforced, with the Second Amendment being applied to white people and felon in possession laws being applied to black people. Talked about the NRA not sticking up for everybody. They're not talking about everybody when they say the people. I think of other examples, the way voting rights have been taken away from the black community through the criminal legal system. I think of the way policing operates. And if one law must be struck down because it is racist, is there an opening to strike down other laws because they are racist? The good news is we don't have to wait for Justice Brett Kavanaugh to strike down all these laws. We in fact have an opportunity, as D.A. Williams has shown us here, as he said, for states to lead, for cities to lead. Cities and states, in his words, are nimble and have an opportunity to take action to reform the way we react to harm, the way we react to transgression. Cities and states have an opportunity to take bold action to move us closer towards justice, even when the courts and our government prove slow. So that's The Appeal Live. I'm Emily Galvin Almanza. You can follow us on Twitter or Facebook, and we look forward to seeing you back here again soon.